My Lord, I just finished my remarks in relation to GenComp and what it tells us about the operation of the regime of the code. And my learned junior points out that if one looks at the last paragraph of that judgment, I won't take it to you now, it does actually talk about the way in which the regime of the code is supposed to operate. This is the way the regime is supposed to operate in relation to that. So we say there's a holistic effect of what's said in GenComp. And with your permission, I will now move on to the solution to this issue lighted upon by Mr Justice Fancourt. And it's essentially this, that he concluded that it's enough that the operator has assumed primary responsibility for complying with the terms of the licence, was the words he used, whether or not the operator has made a deed of covenant with the site provider. The deed of covenant, as I've already prefigured, is something of a short form. That's the way, a way in which we suggest it is possible for someone to become obliged to the site provider to perform the obligations, but there might be other ways of doing that.
So, sorry, on your case, deed of covenant is not necessarily the magic. There could be other...
Yes, it's a shorthand for the person in the position of the operator, the assignee of the operator, having bound themselves somehow to the site provider to perform the covenants. But the key point is that they're bound to the site provider.
Or the site provider's predecessor in title, I think, is one of the points taken against.
Yes, I will come to that, my lord, yes. We say that's not a difficulty at all. The operator can assume primary responsibility. So that's not a concept. Primary responsibility is not a concept in the code, or in, as far as I can work out, the law of contract, in the sense that it's meant. You can assume primary responsibility by giving indemnity to your immediate predecessor. And that's really all you have to look at, whether or not you have given an indemnity to your immediate predecessor. As I mentioned before, and will now look at, my lord decided that whether or not the site provider has any remedies against the party to the agreement is irrelevant. It's not material. And that was expressly found at paragraph 104 of his judgment. Forgive me, 93 his judgment. Page 104. If you're in the fourth bundle, that is. I notified the parties of my view that this was a possible interpretation because it was not one that they had addressed at the hearing, and I had the benefit of further written argument on the point. It's slightly overstating what happened in fact, but I won't go into that. Having considered carefully those submissions, I remain of the view that this is the correct interpretation in the light of the decision in GenComp. I would make clear, so it's clear that my lord is attempting to apply the decision in GenComp by this. I would make clear, however, that I did not reach this conclusion on the basis that the licensor could then seek to enforce the obligations of the assignee indirectly by a chain of covenants made by successive assignees. That's the point I made at the very outset. It doesn't matter whether there's a break in the chain. I reached on the basis that by assuming the principal responsibility, the burden of the agreement, the assignee is sufficiently standing in the shoes of the licensee, at least for the purposes of Part 5 of the Code. Whether it can be sued by the licensor under the general law, directly or indirectly, is a different issue, which is not material to the operation of Part 5. That's reinforced again in the supplementary judgment at paragraph 9. And the way in which that emerged was that when this judgment was concluded, my lord then said, I haven't heard any submissions on whether or not there are such indemnities or anything like that. Can we please put some submissions in? Submissions went in which pointed out the nature of the chains of assignment all the way through them, what they did and didn't say. And the point was reinforced, it doesn't matter whether there's a break elsewhere or a deed elsewhere or whatever. We say that effectively this has rendered the suggestion of primary responsibility somewhat tokenistic. So although it seems to be it suggests, my learned friend, my lord suggests that he is in fact applying GenComp. What he's doing is tokenistically applying it, because the concept of primary responsibility is responsibility, if at all, to the wrong person, and in a limited extent, when compared to the responsibilities, i.e. burdens, which are being discussed in GenComp. So dealing with my lord's reasoning, paragraph 75 of his judgment on page 100, essentially he states that Parliament must have intended that Part 5 could easily and sensibly be applied to substitute operators. Well, we say that it can easily and sensibly be applied by applying our solution. And the converse is not necessarily the case. At 76, he observes that if the licence doesn't restrict assignment, the full benefit of the agreement can be assigned consistently with the policy of the Code for new agreements, and the assignee operator would effectively step into the shoes of the licensee. Well, again, insofar as my lord is attempting to apply the policy for new agreements identified by Law Commission and thus Parliament, he is mistaken, because the policy is very explicitly that the burdens should also pass on assignment. So the thing which is to be facilitated isn't the thing which my lord has identified there. And that is not the concept of stepping into shoes, as I hope I demonstrated this morning, which my Lord Justice Newey identified in GenComp. It's a different kind of shoe. Then at paragraph 77, my Lord observes that it's the assignee who is intended to have the benefit of the continuation and who's likely to be affected by a notice to terminate. Well, although that's potentially true, the benefit of the continuation is for everybody, in fact, including the site provider, in the sense that the site provider continues to benefit from the obligations under it, but also it's for anyone who's sharing. And in terms of who's likely to be affected by a notice, again, lots of people will be potentially affected by notices in relation to this, notices to terminate. But both parties, the original assignor and the assignee, are both affected by the notice to terminate. But it's not just, of course, a notice to terminate, because, of course, it also includes notices to modify. And as we've just discussed, that might be modifying burdens or obligations which don't fall on the new operator. Those are burdens which are entirely between site provider and original operator. A further problem with that proposition, of course, is that those problems, insofar as they're true, or that observation, which is the notices should be, you would expect the notices to be landing on the doormat of the new operator, are equally true in relation to a bare assignment of the code rights without the adoption of primary responsibility. But as we come to see, my Lord accepts that it's not appropriate for the bare assignee of the code rights should be treated as a party to the agreement. Of course, I'm conscious of the fact that to some degree that's grist to my learned friend's mill in relation to that, because his case is, of course, it's just the benefits, you can ignore all the burdens in relation to that. That doesn't work, not least because of 31.4, but in this respect, it's not solving the problems that are being suggested in relation to the notice going to the wrong place. And of course, as we will come to see, there is the difficulty of us working out whether it's a bare assignment or not. The next point my Lord makes in paragraph 78 is that it would be strange if a form of assignment which was permitted by the terms of the licence did not make one a party to the agreement. Well, that's not strange at all, because of course these agreements are by definition being made under a different regime. This regime didn't exist at all when these agreements were made. If it had done, we wouldn't be here because paragraph 16(4) would apply. And at various points in the judgment, my Lord says the code doesn't require these notices to be an additional deed, unilateral deed to be served, for example, and the parties haven't provided for that. And we're imposing an additional obligation as a result of that. But all of that is effectively the result of the fact that one form of agreement, which was under a different regime, is now being applied under a new regime. And whether the code requires something to be done is, with respect, circular, because my Lord says that the code doesn't require it. Well, we say the code does require it, or something similar to it. So my Lord does say at paragraphs 82 to 87 that it's not enough to have a bare assignment. And the reason why that is said is that my Lord says that one cannot treat, for the purposes of the code, the responsibility for performance of the obligations as irrelevant. But with respect, that is what's being done if primary responsibility simply means a promise in the wrong direction, as it were, a promise up the chain of assignment rather than across the contractual divide. Ultimately, responsibility performance begs the question, performance of what and to whom in relation to this. And the fundamentality which he identifies in his judgment as arising from GenComp. In 84, for example, this notion of responsibility for performance of a licensee's obligations is irrelevant. The notion that the responsibility for the performance of the licensee's obligations is irrelevant is difficult, both as a matter of general law and in the light of the reasoning in GenComp. But GenComp is entirely directed at the responsibility across the contractual divide, not at all at the responsibility up and down the chain of assignment, which is not discussed. So we say that he has done exactly what he criticises my learned friends for doing, which is to treat as irrelevant the licensee's obligations to perform. Paragraph 85, my Lord does recognise that it's clearly the operator whose breaches are being considered in paragraph 34 who is the party to the agreement. And unless the operator is responsible for making payment, he cannot be late in doing so. So again, that's a very, very odd form of responsibility and responsibility for breach, because actually it's not even a breach of the indemnity covenant unless the person who is being indemnified has been sued and has not been indemnified. In paragraph 87, my Lord suggested that the possibility that bare assignments would be enough would increase the, generated greater risk of uncertainty in relation to the position who was and wasn't the party to the agreement. With respect to my Lord, whether the assignment is bare or not is not affected by the level of formality which is involved in it, and whether or not an indemnity has been given as consideration for the assignment in relation to that. So a bare assignment may be by deed, an assignment with a indemnity may be given in a very informal way. So it's not in relation to a contract. The assignment of the benefits in return for an indemnity could be given presumably orally. So there is no greater risk of uncertainty. What the risk of uncertainty arises because it's not clear across the contractual divide who is responsible for what. And in this scenario, where the difference to whether or not I should be serving my notice on Tower or On Tower's predecessor is governed by something I'm not privy to, which is the nature of the relationship between On Tower and its predecessor. That is, with the greatest respect, the generator of uncertainty here. And my Lord suggests the answer to that is that you can guess that, generally speaking, there'll be an indemnity in relation to these things. But with respect to my Lord, that is just a guess, and it's one which we can't rely upon until we get into court and manage to extract documents in relation to it. And that's why I pointed the court to the limitations on the degree to which documentation can be extracted under the provisions of the code. All we can ask is, do you have ACA? Are you subject to code rights? To which the answer can be yes and yes, full stop. So the broader focuses of my criticism are firstly that it's obviously distorting and misapplying the reasoning in GenComp whilst purporting to do so. So it's not framed on the basis that it's necessary to constrain GenComp or qualify GenComp. It's presented as an application of GenComp, and what we say is, on the basis of the submissions I've just made, it's not really an application of GenComp, because really it's saying that someone is subject to the burdens when they're not. They're not standing in the shoes, a phrase which my Lord also uses, in circumstances where standing in the shoes, as I've identified, means something very different in GenComp. And the viewpoint, the fact that the viewpoint is being distorted is clear in paragraph 92 of the judgment. In the last sentence, any of these have the effect of placing the burden of the obligations in the license agreement on the assignee, so that as between them, i.e. the assigner and the assignee is standing in the shoes of the assignor in relation to it. Whereas GenComp, as we saw, it was C standing in the shoes of B if it was to be immaterial to A. And my Lord, the third broad criticism is one which I've already touched upon, which is that legislative intention itself is being distorted. It's no longer respecting the legislative intention of facilitating immaterial assignments and encouraging those. It's instead suggesting what is in effect a new statutory purpose of allowing access to Part 5 to almost all assignees, apart from the strange exception of bear assignees, given that it makes no difference whether you're a bear or not to the site provider.
What does the judge mean by a lawful assignee? Is that one that's not been done in breach of a no assignment clause?
Yes, my Lord, because it's not clear why unlawful assignees are excluded by my Lord.
It still takes effect as between the assignor and the assignee, doesn't it? An assignment in breach of a no assignment clause. As a matter of contract, I don't think that the code rights could pass. The choose of action in the code rights would pass, because unlike a lease, where an assignment in breach of covenant is nevertheless legally effective, I think if a contract provides that a right cannot be assigned, it is not effective to assign the right. I think it's not effective as against debtor.
Forgive me?
It's not effective as between debtor and assignee.
Correct, but it is effective as between. Yes,
so
my
the
Lord.
Indemnity presumably would still bite as a
Correct
to hold the assignor harmless.
Yes, and my Lord, I take the point which you're giving me, as it were, in relation to this, which is right. That in that situation, the person has adopted primary responsibility in relation to that. But it would be very strange indeed if they were to stand in the hands of the assignee. But of course, as regards the code, they wouldn't have the benefit of the code rights, because as far as they couldn't assert the benefit of the code rights against me as the site provider.
I understand.
So we say, my Lord, that all of these criticisms disappear if the party must also be subject to the burdens. It then gives effect to the statutory policy. It's consistent with the rationalisation in GenComp, and it imposes no practical difficulties on anybody, we say. That leads us to my Lord's criticisms of APW's proposed solution. And I've touched upon some of these already in passing, but the first of them is in paragraph 89, in which is that it requires the assignees to take a step not required by the code. We say that's circular, or by the agreement. And I've addressed that, my lord. It doesn't, but then the agreement originally wouldn't have given anybody continuation rights or the right to renew or modify or anything. It would just have expired. So this is really a consequence of assignees wishing to have the advantages of the code, a regimen of continuation and potential modification, variation of the terms, without the burdens of that. And we say the code therefore does require some further step to be taken. The second criticism is it leaves the assignee in control over who is treated as party to the agreement and when, which is something which is picked up by my learned friend in his submissions. And I said I'd come back to this, my lord made reference to it earlier on. And it's addressed by my learned friend in some examples, which we find in his skeleton, which is in core tab 4, and it's page 65. Forgive me, 42. Did I say page 65? I hope I did. Paragraph 42. So my learned friend gives some examples here. He says, imagine a site provider A grants the license B to operator 1, who then assigns to operator 2, who does not give a deed of covenant, before assigning in turn to D, operator 3. If D gives a direct covenant, then at that point, B ceases to be the party to the code agreement. B has no control over when or if that will happen. There is no statutory mechanism available to B or an intervening assignee who is given a direct covenant to bring this continuing liability to an end. Well, first of all, we observe that he can't bring his contractual liability to an end anyway. And what else is B supposed to be concerned about? He's divested himself of the rights. He can't bring himself, even if we're wrong, he can't terminate his contractual liability. And then in terms of terminating the agreement, there is no statutory mechanism for termination.
By an operator.
By an operator, I should say, yes. So if operator 1 transfers to operator 2, rather than terminating the agreement and saying, operator 2, you can go off and get a new agreement for yourself, operator 1 is effectively accepting the continuation of their contractual liabilities until operator 2 decides to do something about it. So the fact that operator 1 is no longer in control of whether he is or isn't a party to the agreement shouldn't matter. It doesn't matter to him whether he becomes one. The person it will matter to, whether that relationship is created, is the person at the end of the chain when it's created. The second criticism is this is all still true on my Lord Mr Justice Fancourt's solution. You just substitute the words indemnity to assignor for deed of covenant into this paragraph, and you get the same problems. My learned friend's second example is in paragraph 43. If C rather than D has given a direct covenant, then C would have the burden, but D would have the benefit. Hence, APW's case risks fragmentation. Well, that's, I think, the scenario that my Lord was referring to earlier on, which is that, well, either it's being suggested that C gives a covenant after it ceased to have the benefits, which seems a rather far-fetched scenario, but it comes up later on in relation, in the second example in this paragraph. Or, in that situation, we say simply the party to the agreement moves when benefits and burden moves. If benefits and burdens haven't moved, the party hasn't moved. And it's suggested that identifying the party to the agreement becomes uncertain or onerous. Well, it's no more uncertain, certainly not from our point of view, than under the regime which my Lord suggests. And it's not obvious why it's onerous. I mean, for the future, of course, everybody will just give a covenant that they should do that anyway, which is obviously an ideal scenario from the point of view of Parliament. in relation to the current situation, everybody also knows whether or not a covenant has been given already in relation to this situation. And again, it's also true on my Lord's solution. And then the final sentence is the third example, which is the one I just alluded to. If alternatively, APW's case is that it's sufficient that at some point the burdened party had the benefit, then this is likewise unworkable. Using the worked example, C could give a direct covenant after its assignment to D. Well, I mean, in practical terms, is that really plausible? But in any event, the answer is the same, that unless the same party had the benefit of the burden at the same time, which will always be apparent in those circumstances, you can tell where the party to the agreement is. It will be traceable from the documents which are available to the site provider. It's perfectly coherent and sensible to say that the identity of the party to the agreement doesn't change unless both benefit and burden pass. We're not really in a materially different position to the benefits not shifting without notice under section 136 of Law of Property Act, we say. Obviously that's only dealing with benefits in that situation. But it's another regime where notice to the other party to the contract is important in terms of identifying when the relationship has shifted.
Is notice to the other party key to your solution? I mean, suppose the operator for the time being enters into a deed and puts it away in a drawer. What happens then?
Well, no, it's not key. But the answer to this is, why would they ever do that? What possible function could there be in executing such a document and not providing it to the party to whom you will be wishing to identify yourself to as the new party to the agreement?
Does it have effect without delivery as a deed?
Probably not, in fact. My lord, that's a point I don't wish to express a considered opinion in relation, grateful as I am for another point in my favour, my lord. But I see the point. I'm not sure whether unilateral deeds have to be delivered as well. I suspect that I'm not sure the answer to that. Depol obviously can't be delivered, but I don't know the answer to that, my lord, I'm afraid. We will check. And the next point which is made is because the covenant may have been...
Just proceeding a moment, delivery may be the answer. But you say, well, why would anybody want to do that? I mean, there might be a perfectly understandable reason for not wishing to tell the party to whom you made the promise that you've made the promise. If they don't know about it, they can't sue you on it. So why would they enter into the covenant? To ensure that they were the parties to the agreement, to be known as such.
Because they wouldn't... I can't really think of a scenario where someone would not want the other side to know that they were the party to the agreement. My learned friend's propositions all rest upon the fact that the operator wishes to be treated as the party to the agreement, for example, so that it receives notices under the agreement in relation to it.
And it can renew.
Yes, and so that it can itself renew.
Well, of course, it doesn't need to reveal its covenant for that purpose until it wants to renew. But I can see the point about receiving notices.
I mean, it might wish to act nefariously by hiding into a drawer, I suspect. But these are Ofcom regulated entities in relation to this. I suspect that they would... I hear some chuckling from that, rather unexpectedly, from those behind my learned friend. That the fact that they're regulated by Ofcom should cause them to behave properly is a surprising conclusion. Well, I'll leave it there. My learned friend can address that. So, my lord, it's not obvious why anything would arise. Of course, once the thing has passed over, there's absolutely no reason at all why you should expect that the new site provider wouldn't be aware of the existence of the previous covenant. Therefore, know he's dealing with the party to the agreement. And of course, the benefit of that additional covenant can also be assigned if it doesn't pass automatically. It's an interesting question whether it passes automatically, actually, because this is an unusual scenario, whether or not these obligations would touch and concern. Of course, licenses don't ordinarily touch and concern because they're not interested in land, but these code rights statutorily bind the land.
But on your case, it's good enough if you give a covenant for the period that you've got the benefit.
Yes, but you'll still be the party to the agreement even if you...
No, I see that, but in that case, there's no question of assignment of the deed helping, because if you've no longer got the benefit, then the covenant is an end anyway.
I'm sorry, what I meant, I was considering a situation where the site provider assigns to another site provider too. An uncertainty which might arise, which is something which is touched upon in the submissions from a learned friend.
Yes, I see.
And in the judgment. In that situation, it's difficult to see how there would be any difficulty in relation to that. If, for example, the the only circumstance in which site provider 2 is not a party to the agreement, because it's always bound by the obligations in this situation because of the way paragraph 10 operates. The only way is if it doesn't get the benefits. So it acquires the land without the benefits of the agreement. So the benefits of the agreement have to have not been assigned directly and not touch and concern. And in my submission, they would touch and concern because they'd be concomitant to obligations which bind the land. Just as a surety covenant given in relation to obligations under a lease which bind the land, the surety covenant obviously touches and concerns as well and therefore passes. So it's very difficult to see from the conveyancing point of view where the problem arises and indeed where any uncertainty arises. It actually makes the whole thing work and the whole regime work really well. Because actually what it does is it means that everybody is operating in the way which the draftsman, with respect, must obviously have assumed was going on, which is that burdens are passing around and that the benefits and burdens should be the parties to the agreement, but also Parliament wants site providers who are inheritors of sites to be responsible, operators who are the inheritors of sites to be responsible to the site provider for them, quite plainly. The next point my Lord made is that there'll be a lack of clarity because a course of dealings could have bound them to the agreement. Well, a lack of clarity would still arise factually in relation to the question of whether they were responsible for the obligations in that situation. So the contractual lack of clarity would still be there without our solution in relation to that. In fact, as I alluded to before, it's rather difficult for the course of dealings to make someone subject to all of the burdens of an agreement without that amounting to a novation of the agreement, which of course is problematic for the reasons which I've identified. But in any event, if something happens which creates a lack of clarity, that's because they haven't taken the solution which is available to them of providing the deed which fixes the problem. What we say is all of these solutions, or that is my Lord's proposal, my learned friend's proposal in relation to no burdens, and our proposal, give some, well, we say the least lack of clarity, but some, and certainly theirs gives more, and we say my Lord's solution is the worst. It's the worst of all possible worlds because it relies on dealings to which the site provider is not privy, and which it can't get using paragraph 39. It might get them if a court subsequently orders them, or they're voluntarily disclosed at some point. We eventually got the conveyancing history in this case, but it took some time. So it's the worst of all possible worlds. The site provider serves his termination notice and has to wait for the process to tell him whether it was good, which the process might not even begin for 6 months after that. And this is a site provider who might be serving a notice because they want to redevelop their land, for example, which is an unacceptable scenario. My Lord, at various points, my learned friend has suggested risks to the operator from our solution, which I should address. And effectively, there are 4 categories of such risk. We address these in our skeleton at 618 and 622, but my Lord, I will go through them. The first one is notice going to an operator who's not now concerned with the site, who's not practically concerned with the site. The first observation, of course, is that is a threat which is also true in the case of a bare license assignment. On my Lord's issue, but the second solution, or the second answer, is the one given by my Lord in the judgment at paragraph 96, which is not a practical solution because the notices are in fact likely to come to the attention of the right operator in relation to it, who can then fix the problem at that point, because although he isn't the party to the agreement, he can make himself the party to the agreement and then can be the party in relation to whom the proceedings have to be brought. The second is my learned friend's proposition that proceedings might have to consider the wrong business needs. When we looked, my lord, at paragraph 3413A, which is the things to which the court has to have regard when it's considering modifying or renewing. And I drew your attention to the provision my learned friend relies upon, which is in relation to the business needs of the operator. And my learned friend says, well, that has the risk that the court would have to consider the wrong operator's business needs in relation to that. Well, I've given the court one answer in those circumstances anyway. It's all the circumstances including that. But perhaps the better answer is, how is this scenario going to arise? How is the court going to be considering modification of the terms without the right operator being the respondent to the application? This postulates that we've issued an application against an operator, not only served a notice on the wrong operator, but actually made them a party to the proceedings. And this has all gone on without becoming apparent to the right operator that they should be a party to the proceedings. The same also answers the points which my learned friend's submissions make in relation to applications for interim modifications or interim changes of rent. That the right to do that would be vested in the wrong occupier, the wrong operator would be a better position. Well, the assignor operator is not going to be applying for any modification. If the assignee operator wants to modify the terms, why would it not be bringing itself into the concept of making itself a party to the agreement? If it wants to modify the terms, it just makes itself a party to the agreement. What risks greater incoherence is operator 2 being able to apply to modify the burdens to which it is not subject. And indeed, as we looked at before lunch, it's not clear indeed how that operates in circumstances where operator 1 isn't a party to the agreement, but is the person with the burdens. The third category of risk that's raised by my learned friend is the risk to the operator of unexpectedly losing the site. And therefore, as my learned friend puts it in paragraph 46, in very high terms, disruption to the network. All those points about the practicality of having got to the end of a set of proceedings determining agreements and the notices not coming to the attention of the parties still apply in these circumstances. But even if you got through all of that, and even if someone in the position of my client managed to determine the agreement without the participation of the person with the benefits of the code agreement, the code rights, we still have part 6. I can't get them off the land. I can't disrupt their network without serving notice on them, and indeed every other operator who is on that land, whether they've got code rights or not, requiring them to leave. At that point, they can apply under Part 4, and if they apply under Part 4, that is an answer to the claim. I mean, an absolute answer to the claim, unless they, for some reason, the court won't give them an agreement under Part 4. If the court won't give them an agreement under Part 4, that's fine. That's a circumstance in which they shouldn't be there under the policy of the code. And we have, in fortifying that, of course, if there are emergency rights which are necessary in order to facilitate the continued occupation of land, we have the temporary and the interim rights. And the temporary rights under paragraph 27 are specifically designed to protect operators who find themselves on land and suddenly need a right because otherwise they're in trouble because they've got no right to be there. Then the fourth category of risk suggested by my learned friend is the risk created by someone in the position of On Tower having to use Part 4 rather than Part 5 to get a new agreement or to get new rights. And that's on the basis that under a renewal, proceeding after a renewal notice under paragraph 33, the court's not being required to consider the public benefit test, and there is no defence to a renewal claim of redevelopment. But as I tried to explain at an earlier stage, the way in which that can still be defeated, a renewal can still be defeated by the site provider, by at that stage serving a termination notice and then bringing all of the claims into court at the same time. That's how the scheme works. If On Tower tries to renew, and we say the public benefit test is not met, or we say we wish to redevelop, we serve a termination notice, and then the court deals with both claims, which is exactly what happened in the recent case, which is soon to be heard by the Court of Appeal in a site which is known as Steps Hill. Precisely those facts. So in fact, the public benefit test is still a matter which the court can consider, whether you're under Part 4 or Part 5. The only difference is a difference, as it were, a distinction without difference, which is that if you're under Part 4, the court is required to consider it automatically, but in practice, unless it's put into issue by the site provider, it goes without saying. Whereas in Part 5, the court's only required to consider it if we put it into issue by serving a notice. But either way, whether it's considered is determined by whether we want it to be considered. And that's true also in respect of the redevelopment clause. So although my learned friend says the public benefit test will then have to be answered in every case where Part 4 is used, it will immediately have to be asserted in a Part 4, and then if it's put in issue, then it would have to be considered as well as if it was put in issue on Part 5. So those are the categories of risks, and I hope I've demonstrated to the court that they're illusory. There are no risks to the operator suggested by what's being proposed. All there are is benefits from what was being proposed, which is that the right parties owe each other the right duties. Turning to On Tower's other criticisms, there's a suggestion that it's absurd for the operator in situ not being able to renew or modify the agreement. Well, they are able to, they just have to take a step to do so. What is absurd is the ability of someone to modify obligations to which they are not in fact subject. But actually this comes back to a point which is already made. It's not the operator in situ that the code is concerned with. Part 5 isn't dealing with occupation at all. We've already considered in many points in my exposition of the code, many points at which the code is specifically contemplating there will be operators around who aren't the ones who are being dealt with by the processors of the code. Because they're sharing, because they're present under an expired agreement, or because, as sometimes the case, they've got onto land without ever having a right to be there, for example, because they didn't realise they didn't have the right. And again, of course, if there is any problem, it is instantly soluble by pulling your standard form deed of covenant off the thing, signing it, filling in the parties' names and sending it off. Next, my learned friend says that APW solution still requires a purpose of interpretation of paragraph 31.4. That's the one which identifies the grounds for breach, determination for breach, etc., etc. Yes, that's true, because, of course, in our scenario, they won't be breaching, strictly speaking, the agreement. They'll be breaching their obligation to carry out the burdens of the agreement in that situation. But that is still consistent, we say, that interpretation is still consistent with the concept of the assignment of a party to the agreement being someone who is bound by the obligations. And everybody else's solutions does much more violence to that clause than ours does. Mr Justice Fancourt's, my Lord Mr Justice Fancourt's solution postulate that operator 2, the assignee operator, may have no obligation, continuing obligation, to anyone at all in relation to this. They may have given a time-limited indemnity which is now expired. In any event, their covenant was only to indemnify. You have to do a lot more violence to the clause to say that operator 2 in that situation is breaching things. My Lord made the point, and of course I've already answered it, which is that what wouldn't there be a breach of the agreement by the other operator? Well, it depends on the nature of the obligation, which is concerned.
You just pause for a moment while I look at 31. Yeah.
Next, my Lord, my learned friend has said a number of times, at a number of stages, the code didn't envisage any distinction between leases and licenses. And my learned friend makes that point to suggest that it's not, the code isn't envisaging that someone would have to take a further step just because it happens to be a license in relation to that. And we say, and we continue to say, that this is a point against my learned friend. As an assignee of a lease, it cannot but be subject to the burdens to the agreement. In all of the other possible scenarios, but this one, the party to the agreement is the one with the benefits and the burdens of the agreement. Why, we say, should a distinction be made for this single case? That the code doesn't, in fact, in this particular scenario, require to be treated as the parties to the agreement that you have the burdens as well. And it's not as if the operators, or at least the operator in this case, is saying that they shouldn't have the burdens, because of course you're about to hear a load of submissions to the effect that they do have the burdens in relation to this. The last one is the suggestion that it's an onerous step. The word onerous is used quite often. It's not onerous. All you have to do is to execute a deed in a standard form saying that you'll adhere to the obligations. My learned friend complained in his submissions, I should just flag this point, that by using as my illustration one of their deeds, which has been given to us in a different case, I'm submitting further evidence in relation to that. I wasn't intending to avoid making submissions in relation to Ladd and Marshall. I'm sure the last thing the court wants to do is to hear submissions in relation to that. I'm simply putting that forward as an example of what you can do. It just happens to be one which the operators have in fact done. But the real question is whether it's an onerous imposition in relation to that. If it's any imposition at all it is an imposition which requires site operators who have the benefit of code rights to make sure that they're responsible for the obligations under those things to the site providers. That is not something which the court should shy away, and Parliament has not shied away from making sure occurs. It's something which the court should be actively encouraging to support the regime.
If the assignment is time limited,
yes,
and the assignor's interest is not time limited or not as time limited, is the deed one to perform the obligations that the assignor owes? Or can it be one that's limited to the duration of the assignee's benefit?
I'm sorry, my lord, can you ask the question again?
Yes.
I got lost.
If there's an assignment of a time-limited nature.
Of what? The benefits?
Of the benefit.
Yes.
So
it goes back again.
Potential reversionary
yes.
Interest in the licence by the licensor.
Yes.
On your solution, does the deed have to be undertaken by the licensee to perform for the full period of the licensor's obligations?
Yes.
It does.
Forgive me, for the full period of the person's obligations under the lease, under the reversionary assignment of the licence, because at the expiry of the reversion, of the period of the licence, forgive me, let's put it a different way. at the expiry of the period after which the licence reverts to the original licensor, the original licensor has then got the benefits and burdens again, so it will become the party to the agreement. Conversely, the person who is temporarily the beneficiary of the code rights no longer has the benefit, although it might have had the burdens. So as long as it had the benefits and burdens, the burdens for at least as long as the benefits, as it were, then it's fine.
So can I just double check what in that scenario has to be undertaken in the deed? I'm not sure I understand the answer.
Well, so if you're postulating a transfer for a year of the rights, for example, then for the period of that year, the assignor has to have, during the period when they have, let me do it by example because it's going to be easy to explain. So in my 1 year example, if the deed which went along with that to the site provider was for 1 year, there would be no difficulty.
Right.
If it was for 10 years, there would be no difficulty, although it would cease to be the party to the agreement when it lost the rights, because they would revert back to the original party. If it was for 6 months in that scenario, the court can make a decision about that. We don't need to decide it on the facts. My suggestion would be that at the end of the 6 months, it would still remain the party to the agreement because nobody else has since acquired both the rights and the burdens, because the burdens still lie with the operator even though its obligations have ceased in that scenario. But you could find that it's not sufficient for it to be anything other than for the full duration of the rights, which would be my ideal solution, because what we're actually trying to achieve is that site providers are given deeds which provide them certainty that they can enforce the agreement.
Can I perhaps get even more complicated? So you have a 1 year assignment.
Yes.
And the assignee gives whatever kind of covenant is appropriate.
Yes.
Then the site provider wants to serve notice. So the site provider serves notice on the assignee?
Yes, if the assignee has become the party to the agreement.
Even though the notice can't take effect for 18 months?
Yes, because that's regularly the case, that the site providers and the operators change during the period of notices. Yes. And that's very common in the 54 Act and in the Code. Yeah, I mean, in fact, I'm not sure whether it happened in Gen Comp during the proceedings. Yeah. The notice is good if it's served on the site provider or operator for the time being. My Lord, I should say that I accept that practical solutions are necessary in relation to these, which satisfy the obligations of the code, and I can see that one can contrive quite complicated contractual scenarios to create issues in relation to these issues, which never actually arise. What we're actually talking about is the paradigm cases, and that's how Gen Comp was decided, on the basis of the paradigm cases. Somebody becoming somebody else's landlord or quasi-licensor, or someone becoming their tenant or quasi-licensee because they've been assigned something in that situation. But things do get complicated in the code once you have to start difficult scenarios, and the code keeps throwing up cases because when something gets complicated, the wheels come off. But ultimately, my Lord, we have to find a solution which works for the general case.
I see it's not a robust enough vehicle to carry too many complicated hypotheticals. True on both sides.
Yes, my Lord.
It probably isn't possible to answer this really, but is it possible to say anything about how much this actually matters to site providers?
Well, it matters. Well, actually, I'm just coming on to this.
Yes,
I'm just looking at a heading which says, "Why does this matter to APW?"
Very good.
Your Lord anticipates where I've got to.
Yes.
This is addressed at paragraphs, if you're looking at paragraphs 29 to 35, 629 to 635 of the skeleton argument. But I'm not inviting you to go to look at that now, my Lord, just for your note, so that you're trying to tie things together. Ultimately, this is currently a jurisdictional point about getting into Part 5 rather than Part 4. There are differences in effect in relation to Part 5 or Part 4, depending on how you've got there. So there might be minor benefits to one side or the other by being in one or the other. But we say ultimately the scheme needs to be coherent, so there's a sort of a sense to it. And ultimately Parliament has effectively promoted a policy which we wholeheartedly endorse, which is that assignments are fine, but the people who are assigning should make sure that the people on the other side of the contractual divide aren't affected by it. And this is one of the ways in which this occurs. So this will be a way in which the policy of the code causes that to be given effect. Privileges of the code shouldn't be available to those who have only taken the benefit but not the obligations, even though the benefits may have accorded them a status of security in that situation. They shouldn't have the benefit of being able to fiddle around with the rent or modify the other terms of the agreement.
I mean, that suggests two possibilities. Either you are concerned to get the benefit of the covenants. So in practice, is there a problem with assignees not performing the original party's obligations? I don't know. Or you're concerned to stop assignees being able to resort to Part 5 when you say they can resort to Part 4. But if Part 4 achieves much the same as Part 5, is that such a worry? So
well, they're not quite the same. There are different advantages. So Part 5 does have advantages and disadvantages to the site provider, advantages to the operator. That's absolutely true. And it is nakedly true that it's in our commercial interest for them to be going under Part 4 rather than Part 5. One of the reasons for that is the process by which the rights are acquired. Part 4 has no interim provisions. So whilst the Part 5 agreement continues, we get the benefits of whatever the agreement currently is. We don't get suffer the privilege that the operator would have of being able to, for example, seek an interim rent. That would be one example in relation to that.
Yeah.
But equally, there might be lots of obligations that we are perfectly happy with and that we wouldn't want anybody else to fiddle around with in relation to this. And they shouldn't be allowed to fiddle around with those obligations unless they're actually taking the obligations. But actually, as your Lordship anticipates, APW also needs, not just wants, but needs certainty in relation to this. And what my Lord, one of the things which is, I will come on to say later on is, APW at every stage of this litigation has said, if paragraph 12.1 did what On Tower says it did, we'd be perfectly happy in that scenario because the benefits and burdens would be passing each time. Fine. That's what everybody understands. It just doesn't do that. But also that means that the position is completely certain in relation to that from the point of view where we are. We know who we can serve a notice of. So we want certainty. But we do also want, I have to say, the ability to be able to enforce these agreements. At the moment, the scenarios can arise where we can't enforce them against anybody. Partly my Lord's point about whether or not they're implied indemnities, which we've looked at and I'll answer in my reply, my Lord. I think the answer is no, we think. Your Lordship has taken us to the right cases, but it seems to be an issue about subrogation. Because both parties owe the obligation to the landlord, there's a subrogation between the two. But of course, we have the problem that there isn't an obligation to the landlord in the licence scenario. Anyway, the scenario arises where we can't enforce at all against anybody in these situations. For example, because the original, the very first licensee is gone, or is a licensee of straw. And also, what we can't definitely do is compel anybody to perform the agreement. We couldn't get an injunction against anybody in relation to this. Even if everybody was still standing, they're only indemnity covenants. So we can't do anything. That's not an ideal scenario. And if this encourages operators to put themselves in a position where that's no longer true, great. And perhaps the most striking example of this is what happens if an operator no longer wants the agreement. It may have lots of obligations under these things, for example, to reinstate the property, but in fact what he could just do is walk away tomorrow. Well, look, before I move on to the alternative cases, I finish with this. My Lord Mr Justice Fancourt recognised that the need for certainty does support APW's example. It says that in paragraph 73 of the judgment. And I think I may have already said this, but in terms of certainty, my Lord's solution is the worst of all possible worlds. Because the status isn't constant and predictable from our point of view, as it would be if you supported it on Tower's case. And it's not knowable by us. It is only guessable, and we can't know until the proceedings start, without the operators choosing in their commercial interests to tell us or not tell us. It's right to point out that there is a commercial rivalry in relation to this case. You may have picked this up already, but APW has traditionally been, its business model in the UK has traditionally been to acquire sites and then receive the rents, perform the obligations to the landlord on behalf of the landlord, and that's how it made its money in relation to that. The AP Wireless Group has established an alternative provider called Icon as a wireless infrastructure provider. So it has masts, like On Tower, in relation to that. The reason I mention that is simply to say, my Lord Justice Fancourt, my Lord Mr Justice Fancourt makes propositions about the fact that we can ask questions in relation to this. It rather ignores the fact that these are commercial rivals in relation to this scenario. The suggestion that everyone can play nicely is occasionally made by the Upper Tribunal as well in relation to this. They seem to have stopped making that suggestion more recently because of the disputes which have arisen. My Lord Mr Justice Fancourt's final suggestion was that commercial common sense benefits the arguments that are put forward by On Tower. We say that's not right, because commercial common sense doesn't say that the person in occupation can simply walk away or should be allowed to continue in a position of privilege and be able to just walk away. My Lord, I now turn to the alternative cases which are put forward. The first one is benefits alone are enough. Many of the points which I've just made tell you why that's not the case. The analysis of GenComp tells you why that's not the case. Perhaps the only additional point which I need to address is that my learned friend points out that paragraph 33(1) doesn't mention burdens of the agreement at all. Well, with respect, that begs the question of whether the party to the agreement requires one to have the burden of the agreement. But it does talk about the agreement, which isn't just the rights. And there is a distinction, as my Lord pointed out in the judgment below, between, the code clearly distinguishes between rights and agreements. And of course we have 31(4), which is clearly talking about the burdens of the agreements, the termination provision. And I repeat the submission I made, it would be very odd if the code contemplates that all possible assignments, as it were, notwithstanding this is effectively the only scenario in which the burdens aren't passing, because of course in the site provider the burdens always pass because that's the way paragraph 10 operates. It's odd if the code operates on the basis that in one scenario it's completely a matter of indifference, the burdens haven't passed. The second alternative analysis is that the burdens pass under paragraph 12, because paragraph 12(1) imprints on the code the rights, on the code rights all the obligations of the agreement which conferred it. My Lord, perhaps it would be useful to look again at paragraph 12,
You were going to show us the predecessor.
I am, my lord. Paragraph 12 is it 388 in bundle 2 of the authorities. A code right is exercisable only in accordance with the terms subject to which it is conferred. I repeat, APW will be contented this with the right answer, but unfortunately it doesn't think it is the right answer. My lord, in the judgment below, made a number of points. In paragraphs 103 to 112 is where he deals with it in the judgment. The first point he makes at 107 and 108 is that that's not what it says. It's dealing with code rights, not the... and what the code rights are subject to, not the agreement. It doesn't say that all of the burdens of the agreement pass. And as my lord says, it's directed at the terms and conditions to which that code right is subject, not the burden of the agreement as a whole. And the language isn't apt to extend to obligations that are independent promises, which have nothing to do with the exercise of the right. Well, he says independent promises including the licence fee, which is an independent promise to pay. We were sort of in the same territory as mutual benefit and burden in that concept. And he explains the purpose of 1 is to provide the extent of the indemnity which is given by 2, subsection 2. We say that in fact, it's a bit more, even more complicated than that. Code rights are defined in the code as being general rights, as in a right to install ECA on land, is how it's phrased. Paragraph 12.2 grants statutory immunity. Paragraph 1 identifies that it doesn't grant you statutory immunity generally to install rights on land just because you have the Class A right. It's only subject to and in accordance with the limitations of the agreement which you have been provided to. And you don't get statutory immunity if you exceed the bounds of the limitations of the right. The third class of points which he makes is in relation to the interaction of this provision with 16.4. Now, your lordships remember that 16.4 is in part 3, which was for a while and now almost entirely disapplied in relation to this agreement. But notwithstanding that, if we look again at 393 and 16.4, the observation is made by my lord that this would be an unnecessary provision if 12.1 was doing that already in relation to that. But it's even stranger that it should be disapplied. Why would you disapply 16.4 if the effect of 16.4 is positively misleading, if the effect of 16.4 still occurs because of a different provision in the same agreement? My learned friend says, my lord below was wrong to say that the wording is not apt to impose obligations which are independent promises. And the submissions are made in relation to the fact that rights may be conveyed without any terms at all, and that it doesn't say rights, if any, in relation to that. In my submission, those semantic points don't really go very far. A code right is exercisable only in accordance with the term or terms subject to which it is conferred. Term or terms, of course, having to be read in by the fact that the singular includes the plural and vice versa in relation to that. Of course, every code right is subject to at least one term, which is its duration. The third point, which goes to my lord's question, which is that it says that paragraph 2.5 of the old code shows that this was the intention when it was enacted in 12.1, because it's addressing the same point, and it must have meant it in that one, or it's clearer in that one. If we look at 497, that is where 2.5 is to be found in the bundle. A right falling within subsection 1 above shall not be exercisable except in accordance with the terms, whether as to payment or otherwise, subject to which it is conferred, and accordingly every person for the time being bound by such a right shall have the benefit of those terms. My learned friend says that this makes it clearer that it's intending to imprint all of the terms onto the burden of the terms onto the agreement. Actually, what it makes it clear, what it makes clear is that this provision in its original format was actually intended to move the benefit of the terms around, not the burdens of them. And that's an observation which is made by the rather more detailed analysis of these provisions in the judgment of my Lord Mr Justice Edwin Johnson.
Just before you go there, so
yes.
A right falling within subparagraph 1.
Yes.
What does subparagraph 1 say?
Subparagraph 1 was the rather more laconic version of where the code rights are to be found.
Yeah.
On the previous page, an agreement in writing of the occupier for the time being of any land shall be required for conferring on the operator a right for the statutory purpose to execute works on land, etc. So effectively the first part of the code, or first two parts of the code, were originally one paragraph or one sub-paragraph of the old code.
Yes, that's it.
The indemnity provision is also in forgive me, the statutory immunity provision is also in the old code. It's just in a different place. It's now in paragraph 4.1, or it was rather in paragraph 4.1, which is on page 502, if the court wishes to look at that. My Lord, what I invite you to do is to find in the authorities bundle tab 13 and page 349. This is the judgment of my Lord Mr Justice Johnson. I'm sorry, I should have said it's in bundle 2 of the authorities bundle, so you're still in the same bundle. I should explain how the issue arises. Again, because it was suggested at some point, it doesn't, of course, you're not bound by this decision anyway, but because it's a decision of the Upper Tribunal Lands Chamber. But it's actually a preliminary issue in relation to the same cases. It was the first preliminary issue. The first set of preliminary issues were to determine whether or not these things were leases or licenses. One of the reasons why uncertainty arises in relation to this is because the operators have taken a somewhat fluctuating view about whether they want them to be leases or licenses over time. In this scenario, it was deciding whether or not some of these agreements, which we said were leases, were licenses or not. And the point that was arising at this point was that some of the agreements, one or more of the agreements, I can't now remember, indicated that they were intended to be binding on successors in title, which would obviously be an indication that the parties to them intended them to be leases. And the answer that came from On Tower in relation to that, not my learned friend, Mr. Radley Gardner, KC, the answer that came from him was, oh no, that's fine. It doesn't necessarily, although licenses don't bind successors and titles normally, they do under the code because of 12.1. So 12.1 was being used to interpret the agreements, but nevertheless, the court had to decide what 12.1 meant. And in fact, at the time, it would have been 2.5. So it's dealing with 2.5, but then goes on to talk about 12.1. And so this, my Lord, Mr. Justice Edwin Johnson deals with this from 2.10 onwards. He explains, he identifies 2.5 and then 12.1. And at 2.14, he suggests the first of the two difficulties which arises in relation to this is that it's reading too much into 2.5. And he makes the point which I just made to you about what the actual function of this thing is, whether it's actually moving burdens at all or whether it's trying to move benefits around. But then he accepts the proposition which has been made by me to you in relation to 12.1, about 6 lines up from the bottom of the page. In some way, I agree with Mr. Holland that the purpose of paragraph 2.5 was to emphasise the primacy of the terms of the relevant code agreement over the terms of the old code, save where the old code provides otherwise. Then the second difficulty he identifies is in paragraph 2.15, which is the operation of paragraph 16. And deals with that at 2.17 onwards. So far as I'm aware, and he is correct, paragraph 16.4 of the code has no equivalent in the old code. Instead, there was paragraph 2.5 of the code, which is succeeded at least in part by paragraph 12.1 of the code, which appears to be directed at the same task as paragraph 2.5 of the old code. The obvious point which arises is that if paragraph 2.5 of the old code had the effect contended for by Mr. Radley Gardner, there would have been no need for a new provision of the kind to be found in 16.4. There would have been no gap in the transmission of the benefit and burden of the code rights to the old code, which paragraph 16 was required to fill. If, however, there was such a gap, i.e. because 2.5 doesn't do this, the introduction of 16.4 makes sense. It's also to be noted that 16.4 is disapplied in the case of the subsisting agreements as defined in the transitional provisions in Schedule 2. Paragraph 5.1 provides that 16 does not apply to subsisting agreements. If, however, the burden of the code rights under the old code was capable of assignment by telecommunications operators, paragraph 5.1 of the schedule appears to be redundant. On this hypothesis, there would have been no point in disapplying 16.4 of the code because there was no gap in the ability to transmit. Although I do not think that it's necessary to go this far, APW's counsel has also referred me to the Law Commission's document, which contain discussions of the meaning effect of paragraph 2 of the old code. The relevant discussions are at, and there's a whole list of those. I'll come back to that in a moment. The point which is made is that there is no suggestion in any of these discussions that the paragraph 2.5 of the old code enabled the burden of the rights under the old code to be assigned by one operator to another operator. Indeed, paragraph 322, which we've already looked at, my lord, of the Law Commission report made the following recommendation. This recommendation is clearly inconsistent with the suggestion that the burden of the old code rights was fully capable of assignment by an operator under the old code. My learned friend says in his submission that the Law Commission simply didn't consider or discuss 2.5 in the old code. Well, there are 2 points to be made in relation to that. Firstly, they did obliquely by making a provision for something which makes no sense in 2.5, means what's said. So they effectively refer to it by omission. But secondly, they do discuss in detail, paragraph 2 of the code and assignment. You've seen some of those provisions. And that's what my lord is saying. All of those provisions are within your bundles. We've included them all in there. I can give you the page references if you wish to refer to them, but it's probably quicker just to find the relevant tabs and look for the relevant paragraphs from that note. But what you will see when you do so is a very large amount of discussion, including detailed discussions of who isn't bound by agreements and what paragraph 2 is actually trying to do. Because the old provisions, which became paragraph 10, were much more difficult to understand than they are now. So the suggestion that the Law Commission may have missed it, as it were, or just chose not to refer to it is unsupportable. Perhaps I can simply remind you of, you have already looked at it. Well, you're pleased to know that the answer is I can't because my page reference is wrong. But the paragraph which I've already referred to, which begins the exposition in the report 336, which begins with words to the effect of the old code makes no allowance for the substitution of different entities. So the Law Commission's view was it clearly wasn't dealing with what one elephant is saying it was. in relation to paragraph, my learned friend relies upon the parenthesis in paragraph 2.5. But in my submission, that it's just as easy to make any term, any code right, conditional upon a particular item, including an obligation to pay. That doesn't really change anything.
So to be clear, on your case, going back to 12.1, if the code agreement says subject to payment of the rent, you have the right to do the thing. Would 12.1 apply?
If the obligation, the right to was to occupy said it was conditional upon the rent having been paid, then it would apply. Because there would be a limitation that right can't be occupied. Otherwise, you simply have reciprocal obligations under an agreement.
But if the rent's all payable in arrears, for example, it wouldn't work.
But even if it were payable in advance, it'd still be independent obligations because the rent is payable for all of the rights under the agreement, not the right to occupy. That's the nature of a reciprocal contract. That's essentially the point that my Lady Justice Gloucester makes in the Budana case in relation to benefit and burdens, where Budana overrules the previous authority, which suggests that the obligation to pay money under a CFA is sufficiently inextricably linked to the obligation to do the work in order that the two pass under the mutual benefit and burden principle. And she said, that's not right. If that was true, all reciprocal contracts would by definition pass under the pure benefit and burden principle. It's rather the same issue. They're independent obligations in the same agreement. And that's what my Lord below said in relation to this. He explicitly says it's not there to impose an independent obligation like the obligation to pay the rent.
You'd have to have made it a dependent obligation.
Correct, my Lord, yes. And simply saying, as was said below and is pointed out in relation to these agreements, that the agreement is granted subject to its terms, by no means gets you to the point where you lose all of the rights if you fail to do any of the things. They're not preconditions to their exercise. Perhaps
so to speak, comparing with a lease, non-payment of rent might give you a right to forfeit.
Yeah.
It doesn't make your occupation conditional on rent
Correct.
being paid.
Yes, my Lord.
Benefit of the covenant for quiet enjoyment. It's not conditional on anyway. You still get the benefits of it.
Yes, my learned friend says that you get the benefit of the covenant of quiet enjoyment in circumstances whether or not you pay the rent. You can't defend a claim for breach of covenant of enjoyment, quiet enjoyment on the basis that the tenant's not up to date with his rent. Perhaps another point, which is a rather minor point perhaps, but it is interesting. We do have a section, indeed an entire paragraph of the code, which is directed to the question of who is bound by agreements in relation to this. But nevertheless, paragraph 12, which is said to be directed towards this issue, is buried in a different part of the code. If it was intended to be dealing with the question of who is being bound by agreements.
You're referring to paragraph 10 again?
Yes, my Lord, yes.
And I think that's expressed slightly differently.
It is. It is, my Lord.
Who else is bound by code rights?
By code rights, my Lord, it is. But there's a section which is dealing with the incident and who is bound by things in that scenario. Whereas what we have here is something which is tucked away into a provision on the terms. My learned friend says that that the interpretation which both judges, the judge below decided and which we support, makes paragraph 12 redundant, because in fact it's the case that a right is confined in relation to its terms. Well, in fact, the identification that a right granted is not a general right to do something because you've now got the code right in relation to that, even if it's clarificatory, isn't redundant. It's simply doing something which my learned friend says would be the effect of the code without it, but that's not redundant. It's performing the function of demonstrating that that is in fact the case. It's not redundant in the same sense that it overlaps with another provision which is expressly dealing with the same issue. And of course it's also not redundant because it's qualifying the statutory immunity. My Lord, that's all I want to say at this stage in relation to 12.1. I may address it again in my reply if necessary. The third alternative analysis, which is put forward by learned friend, is a new one. So as I reminded the court at the beginning, originally the case was all the benefits and burdens passed under the mutual benefit and burden principle. And that was rejected at first instance and in the court below, effectively on the basis that that's not how the principle works. One burden may be inextricably linked to another right if they're in the same agreement, but the question is what burden and what right, and how are they inextricably linked? Otherwise, you simply have reciprocal obligations in a contract, and then everything passes, and you've lost the principle that burdens don't pass. So that was pressed again below and rejected, and I'm not proposing to say anything about that because my learned friend's case now is new, and what is said is this: GenComp doesn't say, my learned friend says, that all the burdens must pass. On a true reading of GenComp, only those burdens which are inextricably linked to the benefits must pass. Those, rather by definition, pass under the principle of benefit and burden, although that wouldn't actually be strictly true because the principle of benefit burden also requires that they're capable of being repudiated, rejected. So the fourth stage, an assignee will necessarily be subject to the burdens which are necessary in order to make someone a party to the agreement. Thus, all assignees are parties to the agreement. I hope my learned friend will forgive me for referring to this somewhat as a bootstraps argument in relation to it. It really amounts to this: if it has only the things which have to pass need to pass, if they need to pass, they have passed, so it's all fine. Nothing to see here. The first point to make about that is, where does it come from, this principle that some elements of the burden, the whole burdens of this agreement, Parliament's policy is that some element of that makes a decisive difference about whether the person is to be treated as a party to the agreement or not. I mean, I will have to wait and hear what's said about that because I don't understand. The second point is as to what GenComp decides. This whole argument works on the basis that GenComp doesn't say that all burdens pass. But it is completely clear that my Lord Justice Newey is talking about the entire benefit and burden of the agreement. Because he says, for example, at paragraph 75, the person currently entitled to the benefits and burden, singular, of the agreement as operator. The burden of the agreement is the burden of all of its terms. The third point is that my learned friend doesn't actually go to the trouble of identifying what he says are the terms which are there in the past. Essentially, he says that something must have passed. And his example that he gives in relation to this is the licence fee. Now, I pause to point out something which I've already said about this, which is the Budana case, which is in the authorities bundle. I won't take it to it now, but I might have to in reply. Is dealing with a situation where a fee is payable for work being done. That is not an example. That's simply an example of a reciprocal contract. The Baybut case, which is the one my learned friend refers to, he relies on to say that the two are inextricably linked, is a difficult decision for him. The facts of the Baybut case were that there was a transfer of a caravan site. The caravan owners occupied under licences. The transferee gave notice to the caravan owners that they would their licences were being brought to an end. The first issue, which the court had to decide, the deputy judge had to decide, was, were those agreements subject to minimum terms of 10 years each through various dealings? If they were, the court would then have to go on and deal with the question of whether they were binding on the assignee of the licensor. And so, having decided that they were not, he then explicitly, obiter, went on to consider, nevertheless, whether they were binding. His next conclusion was, yes, they would have been binding because they were novated. So that's the second conclusion. The third stage, only the third stage, he decides, if he was wrong about the previous two, is assignment. So it's, as it were, double obiter. And that's the question of whether the burden of the licence was assigned to the freeholder or passed to the freeholder. And he considers Taito and Waddell. My supplementary skeleton makes an error because it says it only refers to Taito and Waddell. That's not right. What I mean is it's only referring to the principle which is identified in the residue of that principle, which is continuing. It's all that's being applied. As it's poorly expressed, I apologise. But fundamentally, the problem is it's the wrong way round. That case, for my learned friend. It's not a question of whether the obligation to pay the licence fee is inextricably linked to the rights to continue to occupy. It's whether or not you can accept the licence fee as the successor of the licensor and then reject the licence. It's a somewhat difficult authority because it only refers to, it's very brief in those regards, but also it does refer to Taito and Waddell. And actually, in the discussion of the principle of benefit and burden, one of the things that my Lord Sir Robert McGarry said in that case is about licences. My Lord, it's behind tab 2 of the authorities bundle. I'm sure your Lordships are very familiar with the circumstances. I certainly don't want to expound on the dealings involved in that case. But if I can just take you to the bit which is always referred to. Benefit and burden starts on page 44 of the authorities bundle, which is 209 of the judgment.
Sorry, page?
44 of the authorities bundle, 289 of the judgment. Sorry, I think I may have misspoken then. And it's under item 6, benefit and burden. And then if we go over to 45, it splits into A and B, conditional benefits and independent obligations. And it's talking about the fact that a right may be qualified by another obligation, which we've just discussed. And then B is qui sentit commodum sentire debet et onus. He who feels the benefit feels the burden and disadvantage. So this is the pure benefit and burden principle applying here. And he's considering how that operates. And of course, this is the principle which is that road back form. But in the course of the discussion, if you turn over to 46, C, obligatory and optional, it's talking about something else. But at letter B, does your Lordship have the sentence beginning, but in the case? I'll just read it. But in the case of independent obligations, the pure principle of benefit and burden, if it applies at all, seems at least in some cases to operate in an optional manner. Thus, if the benefit is a license to cross a neighbour's land and the burden is the making of an annual payment. So in the exposition of the pure benefit and burden principle now discarded, my Lord Sir Robert McGarry points out that the obligation to pay a payment for the benefit of a licence are independent obligations. They're not inextricably linked. So, my Lord, Baybut is a slender reed to lean upon in relation to the proposition that you can tell what that there are inextricably linked burdens in relation to this. But the really central difficulty in relation to that just leads to the difficulty that no findings have been made and no analysis has been conducted about what is and isn't intrinsic to anything else. There's a generic proposition in relation to this. And it may be that there are none at all, and we're back in the it's only the benefits that matter. And that's the reality of this thing. Why is it that a particular little element of burden, if it exists at all, matters? And does it matter if there's no burden at all? I think the learned friend would say no. But none of that is supported by any of the judgments, any of the paragraphs of GenComp or anywhere else. There's no suggestion of why that is. It's simply something which my learned friend puts forward because it would work for his case. But there's nothing else behind it. My Lord, I have finished 20 minutes before 4. I'd like to say that I was mindful of the fact that your Lordships wanted me to stop after 2 days, but really I've just ended. I hope I haven't tried your patience too long. Is there anything else I could address, any issues I could address at this stage usefully?
Yes.
Just to tidy things up perhaps, going back to the code.
Yes, my Lord.
The second volume of authorities.
Yes, my Lord. 14.
14. Looking at part 5,
Yes.
obviously we're grappling with the words, who is a party to a code agreement.
Yes, my Lord.
Excuse me, you pointed out this morning that that phrase cropped up in another part of the code,
Yeah.
but in a context which is irrelevant for our purposes.
Yes, my Lord. In fact,
Certainly
that
we've got-
occurs several times, my Lord. I can give you the
Well-
references if you'd like them.
I was trying to simplify it.
Ah,
Certainly for our purposes, we have this phrase in paragraph 33(1) and also back in 31. Are there any other parts of the code where this phrase is relevant
No.
for the purposes of this
No, my Lord.
issue? Okay,
No.
thank you. My other question then takes us back to paragraph 10. And as you were saying a moment ago, it has the heading, who else is bound by code rights?
Yes, my Lord.
Then we looked at 10.1, code right is conferred on an operator in respect of land by a person who is the occupier of the land.
Yes, my Lord.
And then 2, which gives rise to the possibility of successors and titles and so on being bound. 2 arises if it has an interest in the land when the code right is conferred.
Yes.
In other words, if an occupier also has an interest in it.
Yes, my Lord.
It seems to presuppose there may be some situations where the provider of a code right may not necessarily have an interest in the land.
Yes.
Does that happen in practice?
I have never known it happen in practice. I wouldn't say that. It might happen by accident
Well,
when you've got one from the wrong.
I mean, this
Because it
code applies to licenses and wayleaves.
Yes. It seems to be directed at simply having to go and ask the person who's actually there without having to worry about what their title is in relation to it. And then you create, under 2, you create the benefits if that person does happen to have an interest in relation to it. And if they don't have an interest in it, you deal with it under 4 by making anybody else you need to bound when you discover that they need to be. So if it turned out that the person you got your deal from was just happened to be there and was pretending to be the landlord or whatever it is, in those circumstances, you would then go to the landlord and say, I have this agreement, I want to be bound by it.
So in practice, you don't have licenses, for example, being granted by people who have no greater right themselves than a license.
Well, it's theoretically it might be possible by one code operator to another code operator.
Well,
there's a sort of issue about that.
If that can happen, when there's an assignment of the license that's granted by someone who himself has a license, the burden of that license won't pass any of the benefits.
Yes, my lord.
So the sort of analysis and the
You mean-
solution you're suggesting would need to be applied in that situation as well.
Let me consider the scenario that you're considering. So you have a license. You have a licensor of premises who is granting a code right to an operator. Let's call it that.
Yes,
And
and
then-
have a license.
And then the license itself changes.
Well, your submission, your analysis rests on the basis that in the situation we're dealing with in this case, the benefit passes, but not the burden. But wouldn't that analysis also apply?
On a change of the original licensor,
Yeah.
because he disappears in that situation.
Well, whatever. Whether there's an assignment.
So the licensor has a contractual license to occupy land, and then he transfers that license to somebody else in that situation. Well, the burden would pass.
Well, the burden passes seems to depend under paragraph 10 on whether it constitutes an interest in the land.
I see, yes. Well, that's a good question about whether it would be counted as an interest in land. Normally licenses aren't counted as an interest in land, but by definition, the fact that they become binding on strange people might cause them to be more of an interest in land than they might otherwise be. The benefits, of course, can pass. Say again?
It doesn't say an interest in land, it says an interest in the land.
Forgive me.
So that's specifically referring to licenses.
Yes, oh, I see. My learned friend makes the point, I should say. There are degrees of knowledge of the code, and my learned friend is probably at the very, very apex of them, and I don't know why quite I'm standing here as a sock puppet for my learned friend, but nevertheless, paragraph 10.2, if O has an interest in the land, as it were, my learned friend says that is not an interest in land, it is an interest in the land, and that in that circumstance the licence is thought to be caught by that. But my lord, that's the first time I've ever thought about that point before now, but I will think about it again before I stand up again, my lord, and if I have anything else to add in relation to that, I will.
Thank you.
Thank you very much, Mr Watkin, and thank you too for finishing half an hour before 4:15. Mr Lees.
Well, yes, if I could just take a moment to get the lectern.
Yes.
Oh, I'm sorry, beg your pardon. I understand your lordship to say you're sitting until 4:15.
That would be my expectation, yes.
Very well. And is that true tomorrow as well, my lord Justin?
That would be my... tomorrow, yes. That's what I'd expect. I mean, there's a degree of flexibility. If, for example, at 4:10 it seems that we could finish by 4:30, I suspect we would want to go on to 4:30.
My lord, as my learned friend said at the outset, the question before you in one respect is a narrow one because of the construction of those 5 words in part 5, and as my Lord Justice Holgate has just explored, really in respect, I mean, in this case of paragraph 33, though it's fair to say paragraph 31 would operate the same. And the question as to what a party to a code agreement means, we say, falls to be determined by reference to 2 questions logically. The first question, insofar as the case is put on appeal, is whether a burden is required. That, although we're quite happy to defend the decision of Mr Justice Fancourt, and we say if burden is required, that is a solution. It is logically the prior question, is burden required? And as the Court of Appeal, you'll want to answer that question first in my submission. And then secondly, if you say that it is required, how so, and in what capacity, and in what way can that be satisfied? It won't be lost on this court that there's a slightly strange circumstance here, in that it is the site provider who is, as my learned friend rightly said, a site aggregator who purchases sites for the benefit.
I'm finding it difficult to hear.
Oh, forgive me.
It's the site provider who...
This site provider is a site aggregator, so it purchases the income streams from the sites. My learned friend's right to say there is now a sister company who operates, I think, about 50 or 60 sites, I think we've heard in other cases. But still predominantly, there's a couple of thousand sites it owns. It purchases for the income stream primarily. And there's a deep sense of an irony that in this case, it is a site provider who is suggesting that we're not in fact bound, whereas we have always accepted that we are bound as the operator in situ. And I can't remember if my learned friend did cover it or not, but it's right to say in both instances below, it's been accepted. This is not a case where an operator is, for example, in breach or is seeking to avoid liability in any way. It's also right to say that the context is particularly relevant. And what I mean by that is that we are dealing here specifically with part 5 of the code, and my learned friend's taking you through it, and I'll, of course, possibly later today, or if not tomorrow morning, quite early on, take you through certain provisions of it again to explain how we say it fits with our case. But the context is that we're dealing here with where the code has continued the agreement. That is where this term of art, as it were, of a party to a code agreement, becomes relevant. Because as you will have seen, as your lordships will have seen, with regards to paragraph 31, it is only when it comes to seeking to terminate the agreement, and there are only two occasions where that's possible. One is where the contractual term has already expired, and the other, as my Lord Justice Holgate may recall from May last year, is when a break clause is sought to be exercised. Or we get to paragraph 33, which is then when one has to seek to either modify or renew the agreement. And again, as my learned friend rightly says, the time for that is, the time when that is engaged is when the statutory continuation is taking place. We say that context is particularly important because what it is focused on is at that time. That's when you'd be serving the notice, and that is when you're seeking to either renew or, in the site provider's case, seeking to terminate. It is not something that happens during the duration of the contractual term. There are, my learned friend pointed to 6 points that were common ground, and I think, broadly speaking, although we might have different emphases, I think that they were correct. They were common ground. I had identified 6 as well. If I'd had overnight, I'd have refined them to make them simpler. But can I just identify these 6 points? There's some overlap, but they're not entirely the same. The first is it is common ground that the code agreements come in different forms: leases, licenses, wayleaves, and that the code has to be made to work for each of those. Secondly, it's common ground that although many of them, and indeed these two, are licenses, that they are capable of assignment. Now, I use that phrase in a colloquial sense. My Lord Justice Foxton, of course, raised this issue right at the outset about what we mean by assignment, in fact, strictly speaking. But what I mean here is it's common ground that the license code agreement can come to be that the party to it is an assignee. That is common ground, even though the general law would not provide for that strictly. Thirdly, the general law isn't in dispute, as I understand it, in that it's accepted by both parties. The extent of relevance might be different, but it's accepted by both parties that the assignee of the benefit of a contract does not strictly become a party to that agreement under the general law, and that the burden is incapable of assignment. That leads to the next proposition, that it is agreed that this answer of what it means is to some extent necessarily dictated by the code itself. And we say also its context in which it operates. It isn't the general law of contract that answers the question. That is not to say, and indeed as my Lord Justice Lewison pointed out in arguments in GenCom, that everything that the code operates in a vacuum. But the source of the answer, we say, and I understand it to be common ground, must be that it's dictated by the code, not the general law. Because what both parties argue for is impossible as a state of the general law to become a party to the code agreement. And linked to that, I suppose, is the proposition then, that, so we all accept, as Lady Rose tells us we must, in practical terms, adopt a purposive approach. I think I lied at 2 of them, so there became 5, so I've managed to shrink it a little bit. But the correct approach then, I understand those positions to be common ground. And the correct approach, as my learned friend rightly took you to, is what Lady Rose exhorts us to in Compton Beecham. It's paragraph 106. I won't take your lordships to it now, but I'll give you the reference again. It's Authorities Bundle 1, tab 10, page 234. And that is that one looks at how the code is intended to work, and in this instance in particular how Part 5 is intended to work, and then give party to a code agreement the appropriate meaning, as opposed to seeking to interpret that provision and then simply running it through, come what may, come the outcome. That is also the position that was adopted by my Lord Justice Newey in GenCom at paragraph 74. That's precisely, he sought to directly apply that approach. That reference is Authorities Bundle 1, tab 11, page 273. Now, in my submission, in order to answer that question, one has to look at 2 particular things at the outset before we get to the provisions. The first is the overarching policy of the code, what this new code was aiming to achieve. And then secondly, in particular, how Part 5 was intended to operate in terms of the transition of subsisting agreements into being new code agreements. And I'll try and deal with certainly the first and possibly both by the break. So if we look at the policy of the code, there are a number of neat summaries. The first is if we could go to the decision of Mr Justice Fancourt sitting in the Upper Tribunal in the Stevenson case. That's Authorities Bundle 1, tab 9, page 192, the start of the decision. But in particular, if we could go to paragraphs 46 and 47, which are on page 203. And if I could invite your lordships to read paragraphs, well, in fact, I might assist to read from paragraphs 45 through to 47.
Okay, we'll do that. My lord, a number of points just to highlight. The first is, of course, as his lordship says at paragraph 46 in particular, the code is aiming at giving operators broader rights and greater flexibility. The reasoning for that is well set out, and we'll look in a minute at other places we can see that. But in particular, it was because of the new technology coming, 5G is mentioned by Mr Justice Fancourt, but of course there's other technology too. There was also a desire to, and your lordship asked my learned friend earlier about the possibility of if someone wanted to stipulate a higher, I think you used the word rent, but higher consideration. Of course, that's perfectly possible as a matter of theory. In practice, the consequence of the code is the valuations shrink dramatically because they are no longer, they're done on what's called the no network assumption. And so they no longer give you give the site provider the value of it being a telecommunications site. They give it effectively the alternative use value. Effectively, what else? What are they losing? They're losing the ability to use agricultural land, for example, in a greenfield site. Or maybe there's a particular usage that they could have put it to, such as storage or hoarding or something of that nature. And so the purpose behind the code, the overarching purpose, is facilitative for operators and for the maintenance and indeed expansion of their networks and of the equipment thereon. And you can see that in the second half of paragraph 46 as well, where Mr Justice Fancourt specifically refers to the fact that Parliament, in seeking to bring about those cost savings, was in fact changing the Law Commission's recommendation, because the Law Commission's recommendation was a market value. And then the other point I asked you to, although we're primarily dealing with policy of the code here, just note in terms of how Part 5 is supposed to work, Mr Justice Fancourt also identifies in paragraph 47 that the way it's supposed to work, this is about 3 lines down, your lordship will see, it's apparent from the way Part 5 applies to subsisting agreements, pausing there, we know that would include these licenses, that it's intended that as from the contractual expiry of subsisting agreements, parties should have the right to apply for new code rights. The response referred to a steady phasing in of new code rights. It can't have been intended that the public benefits and investment incentives conferred by the new code will be stultified by the continuation of subsisting agreements with more limited rights at higher rents or fees significantly after their expiry dates. So the 2 key points here are, as I say, facilitative for operators with all of those benefits that have been identified, but also that Part 5 is the route of renewal. It's intended. We know that's not true for certain subsisting agreements.
We'll see that when we look at the provisions, because it's not true for business leases protected by the 54 Act. They have, as my learned friend rightly articulated earlier, a one-off renewal through the 54 Act, the end point of which is you are in the code. And here, where we're dealing with licenses that can't be business tenancies for obvious reasons, they aren't governed by the 54 Act, so they are to be renewed under Part 5 of the code. There's also a helpful exposition of this point by Judge Elizabeth Cook, who indeed was previously the Law Commissioner who wrote the Law Commission report, in the Upper Tribunal decision in Queen's Oak Farm. That's in the same authorities bundle at tab 8. And it starts at page 178. It's right to note, of course, that strictly speaking, that parts of this decision were overturned ultimately by the Supreme Court, albeit for the reasons that the judge gave herself in granting permission. But if we could go to page 189 in particular, Judge Cook is again addressing the policy of the code and indeed how Part 5 is supposed to operate. And if we could start at the top on the right-hand corner, paragraph 149, I can invite your lordships to read 149 and 150, and then also 156 and 157.
Sorry, 149, 150, 156, 157.
My lord, yes.
We'll do that. Well, my lords can finish at 156, actually, forgive me. That's 157. Yeah.
So, my lord, what we have here is, again, the Upper Tribunal, and a particularly specialist constitutional office, if I may say so, noting again the key policy drivers, which again are all focused on the operators being able to exercise these code rights, but also being able to renew them. And being able to, and the route of renewal, if it's not a business lease, is to be under Part 5. It's to be noted it isn't to be under Part 4. I'll come to that argument in more detail later, but it is to be noted it's not envisaged that the route to renewal will be via Part 4. It is envisaged it will be by Part 5. And that perhaps is unsurprising, because although we know operators without code agreements could, if I put it, renew their sites by going through Part 4, that is indeed the Queen's Oak Farm and Compton Beecham situation. So in the Queen's Oak Farm one, tenancy of will, but on site, but not a subsisting agreement, and therefore can use Part 4. Where there are code agreements and subsisting agreements, Part 4 is not open and is not intended to be open. It is not intended to be the route of renewal. In our skeleton argument, I'll do this as a short summary. If we could go to the core bundle, tab 4, please. And in particular, paragraph 13, which I think is on page 58. Paragraph 13. Starts on the bottom of page 58. But in particular, the substance is over the page at the top of page 59. We've also identified there some comments from the DCMS report, which obviously preceded the code. In particular, I think A and C, which further set out the policies of the code. So, in my submission, the policy of the code is easily identifiable, and one of the questions your lordships have to consider when considering how to interpret or what party to a code agreement is meant to mean is that it has to be something that achieves that policy. The second point is the part 5 is the route to renewal. I've already shown you those comments in Stevenson and Queen's Oak Farm. There's also the point made in GenComp. If we could just go to Authorities Bundle 1, tab 11, please. And in particular, page 267, paragraph 54, which is the first paragraph I think my learned friend took you to this morning. So it starts at 54, but if you could skip over the page to 268 and paragraph 58, you can see there the Lord Justice Newey, his lordship rightly notes that code agreements are intended to be long-term agreements, continuing despite their expiry of contractual terms and capable of surviving both the change of site provider and the change of operator. And in my submission, that is right. And the reason I flag that now is because when considering that Part 5 is intended to be the route of renewal, there is no suggestion that anyone, parliamentary draftsperson or otherwise, was assuming it would be the original parties. Indeed, that would have been an odd assumption to make, given in practice these agreements, as indeed the agreements before you, are often made for 10, 15 or even longer years, or indeed are made effectively until notice is given, particularly when made by a licence. So they could be effectively perpetually renewable, as it were, until notice is given to prevent the term continuing. There's also a further point, which my own friend mentioned, but I suggest is has a slightly different impact to him, which is retrospectivity. Again, I think it's to some extent common ground that the new code was to have I think it's probably wrong saying no retrospective effect, because my learned friend says it introduces statutory continuation, but a very limited retrospective effect. And certainly a respect is baked in for the bargain of the parties. That, I think, is common ground. But in my submission, that's a key policy principle here, because if, as they were here, they are envisaged to be assignable agreements, then they should be assignable, we say, on the terms of those agreements. And when I come to address tomorrow my learned friend's solution, we say that that would not be respecting the parties' bargain, because it would be imposing an additional obligation which the parties had not negotiated for. We say that lack of retrospectivity is two ways. It is preventing operators, for example, saying mid-term, actually I'd just like to reduce the rent please now that the new code's in force, or I'd like to reduce the consideration. But it also works the other way, in that site providers such as my learned friend's client aren't in a position to impose an obligation on us that the agreement itself doesn't impose for a lawful assignment. And so we say the retrospectivity point is relevant there. The final point at this sort of policy level, and perhaps where I'll leave it for today, is if we could just look at the transitional provisions again. This is in the Authorities Bundle 2, tab 15. Starts at page 453. It's right to say there's a...
Sorry, page...
forgive me, at 453 is the start.
Yes, thank you very much.
It starts with provisions. And we can see there, as my learned friend took you to, a 1/4 subsisting agreement. So that would include license agreements such as this. So there's no dispute that it's a subsisting agreement. In 454, the effect of the subsisting agreement after the code comes into force is it takes effect as a Part 2 code agreement, subject to the modifications that are made here. There are specific modifications we know, one of which is on page 457, which is one my learned friend took you to, which is the disapplication of paragraph 60. But there are other provisions. For example, on page 461, and this is at paragraph 6 of Schedule 2 now, the transitional provisions, on page 461, one can see it, paragraph 6, subparagraph 2, that Part 5 of the code, so this is the renewal section of the code, which will schedule the code we're focused on, does not apply to a subsisting agreement. This is a lease of land in England and Wales if, and then if it's a lease to which Part 2 applies. I don't know how familiar your lordships are, but there is a possibility, even if it's a business lease, to contract out of the 54 Act. So essentially here it has to be, if it's a business lease which you haven't contracted out, then you have the protection of security of Part 2 of the 54 Act, in which case Part 5 is disapplied. Your route to renewal, therefore, as my learned friend rightly says, was that the reason I highlight this provision is it is clear that the parliamentary draftsperson excluded those who were not to have the benefit of Part 5 as the route to renewal. That confirms to us that in making Part 5 work, and in looking at what a party to a code agreement is, it confirms to us that it does include these subsisting agreements which are licenses. There is no suggestion, of course my friends accept them as excluded, but the key point I make is that the parliamentary draftsperson has excluded those who were supposed to, who he or she wished to exclude. And so we know when we come to the provisions of Part 5 that they include licenses. So party to a code agreement has to be interpreted in a way that assignees of licensees that predate the coming into the code, they are to be renewed in Part 5 and not via Part 4. Now, I'm about to embark on a discussion of the Part 5 provisions, and I suspect...
And that's a rather longer exercise.
It's a longer exercise than 4 minutes, so I suspect, my lord, that would be an appropriate moment.
In that case, let's leave it there, and we'll resume at 10:30 in the morning.